Welcome once more. This is Dr. Advocate MILTON. I'm the founder chairman of Center for International Criminal Justice Africa. I hold a PhD in international criminal law, and I'm a professor of law. This is lecture 5. We had very interesting discussions on the basis of lecture 4 topics. And right now we're going to proceed to look at another very interesting area of discussion. As the title suggests, we're going to look at the procedure of arrest of a suspect to be brought before the International Criminal Court. So in this topic, I'll discuss how the arrests are carried out, how the warrant of arrest are secured by the prosecution up to the stage when the arrest is formalized through states and the accused is brought before the International Criminal Court. But as usual, before I proceed with the lecture of today, it's critical that we have a retrospective glance of what we covered in lecture 4 to be able to create a link and a continuity in terms of absorbing what we're going to do. In retrospect, in the last lecture, we did consider very critical concepts and issues relating to procedures and the operations of the International Criminal Court. You will all recall us saying that the International Criminal Court can only have exercise jurisdiction, have power, conduct its proceedings in respect of crimes that appear under the Rome Statute, what I called Article 5 crimes. The crimes outlined in Article 5 and which are elaborated or initiated upon right from Article 6 up to Article 8 of the Rome Statute. The crimes that we are talking about, as usual, are genocide, which we discussed and gave meaning. Two, we have crimes against humanity, war crimes, and the interesting related crime of aggression, which we discussed also at length. All right, having indicated that the ICC can only exercise jurisdiction in respect of those crimes and not any other crimes out. So it has a limited jurisdiction to that extent. It's consistent with the reasoning that only those crimes that are confined within the statute are those that the ICC entrusts itself with or gets involved with. The other thing we noticed is that the ICC, the International Criminal Court, is not a retroactive court in the sense that it does not concern itself with events, acts, omissions, or conduct that occurred, one, prior to the coming into existence of the Rome Statute. What am I saying? I'm saying that if an offense purportedly answering to the definition of genocide was committed, for instance, in the year 2000 or 1995, then such an offense, such set of conducts cannot form subject matter of the jurisdiction of the ICC. That is because under the principle of legality, the crimes that the ICC concerns itself with are only those crimes that were ratified by the member states after 1st July 2002, when the statute came into force. We also noticed that the ICC is a court of a permanent nature. It is permanent in character. And also we realized, we did indicate that unlike the ad hoc tribunals, it was permanent in terms of its conduct. It did not cease to exist merely because a particular situation has been dealt with and disposed of. We know that the ICTR, that's the International Criminal Tribunal for Rwanda, International Criminal Tribunal for the former Yugoslavia, were all confined within the limits of a particular territorial state of affairs and the individuals. And it had a specific mandate that was granted by the United Nations General Assembly. So having had that background, we were also able to proceed and examine how how actually the International Criminal Court comes to exercise its jurisdiction. What I mean is how the jurisdiction of the International Criminal Court is triggered. So that brought us to the last topic, which was the trigger mechanisms for the International Criminal Court. We noted that there are three main trigger mechanisms through which the jurisdiction of the ICC could be triggered. One, we referred to, there was a referral, where a state party would refer the matter to the International Criminal Court for the prosecutor to present before the pre-trial chamber. We looked at that and indicated that once there's a referral, before any proceedings take place in terms of trial, the matter has to be presented before the pre-trial chamber, whom we said they see over what the prosecutor does, without necessarily compromising the independence of the prosecutor. We also noticed that even non-state parties would make a referral if they wished. Of course, they're not under an obligation, generally speaking, under the Rome Statute, since they're not parties, but still they may want to have a matter referred to the International Criminal Court for adjudication, for proceedings to be initiated. So that was one trigger mechanism. The second trigger mechanism was what we call the proprio motu, where at the instance of the prosecutor of the International Criminal Court, a matter could be brought in after the prosecutor has satisfied herself or himself that in the light of the evidence in her possession, they may have to approach the pretrial chamber to be able to sanction, to authorize that the proceedings may go ahead. So there are instances where the prosecutor may have evidence come to her office by virtue of people bringing in sufficient evidence in their, if they feel that evidence is sufficient to sustain a charge, they would then proceed to present it before the pretrial chamber. The pretrial chamber would ultimately decide whether or not the matter will proceed based on a number of factors, whether there's actually plausible evidence to sustain a trial or a charge for that matter. That's not the conclusive stage of the proceedings. It's merely, it does not render the accused guilty if the charges are confirmed. It merely confirms that there's actually a credible case that can be sustained. We also actually brought out clearly that once a warrant is sought, that warrant cannot be just issued by the prosecutor. It has to be authorized. A warrant of arrest must be authorized by the pretrial chamber before it is sanctioned to proceed. All right, the third trigger mechanism that we looked at last time was the United Nations Security Council actually deciding, referring a matter to the prosecutor. If the matter was of such gravity that they feel the prosecutor should deal with, it will be immaterial that the party referred to is a state party of the Rome Statute or not. So meaning the ICC could as well just could refer a matter concerning a non-state party, and that the court would be able to attend to that. Also, it doesn't matter that the individuals involved are not nationals of the state party. So those are the three areas that the mechanisms of for the International Criminal Court jurisdiction could be triggered. Without wasting much time on those areas, we now want to proceed today and examine very quickly what happens when, once we have had the mechanism in place, what is the procedure of bringing the suspects before the court. This presumes the fact that there's been a referral or there's referral, and the charges maybe are confirmed or not yet, but there was a referral made to the court, or referral by the prosecutor actually proprio motu, or the United Nations Security Council, or the state party. So obviously, the ICC has criminal jurisdiction over individuals, not entities, natural persons. So where this suspicion that an offense, an Article 5 offense has been committed, it follows that the individuals that were behind such offenses, and they have to be brought to account. So our concern right now is on how these individuals are brought before the court. How are they, they might be powerful persons in their own political setup. I'm giving example like President Bashir al-Bashir in Sudan. I'm giving examples like the cronies of those powerful presidents, all those who have just decided to go underground, like Felician Kabuga, who has been a fugitive for almost 3 decades, who was just recently arrested in one of the suburbs in Paris. So our question is, how does the ICC operate or conduct itself in respect of bringing the accused person before the court? Okay. Obviously, we have instances where the accused could surrender themselves. So we are talking about arrest and surrender. It's not just a matter of arrest and stop there. We are going to look at how one surrenders, because unless there's a surrender, then the process would be forestalled at some point. So how is the arrest carried out in the first place? Arrest is carried out, as we said quickly in retrospect, just as a sieve to ensure that the process is foolproof. The prosecutor approaches the pretrial chamber to be able to authorize the issuance of a warrant of arrest or a summons to appear. That would depend on the particular circumstances obtaining in respect of a given individual. So once the initiation of proceedings has been launched, of investigations particularly, it would reveal who are actually the suspects in that particular set of facts, and the prosecutor would make an application to the pretrial chamber. That application would be to request that the chamber do authorize the issuance of summons to appear or a warrant of arrest. And the prosecutor must be able to present reasonable, plausible legal grounds to justify the arrest of that person, to point to the fact that actually this person, there's reason for him to be brought to account in respect of the set of facts that have been revealed by investigations that are in their possession. So that's the point. That's the first stage. After identifying who they are, of course, the process, the judges would be interested, the pretrial chamber judges would be interested in finding out who the person is in the first instance, the nature of the crime, and establish whether it's not of, there's no political witch hunt or anything that is not in consonance with the provisions of the Rome Statute, and to ensure that those crimes actually can be pigeonholed within the Article 5 international crimes. So the prosecutor would have also the responsibility to set before the pretrial chamber facts that point to the fact that point to the allegations that actually crimes were committed by this particular individual. They may not have to be detailed, just summary and clearly pointing to the fact that we need this person. By virtue of all these set of facts, he needs to be to appear to account for his acts before this court. All right. It's not just presenting facts and identifying people. the judges may be interested in finding out why actually would have this person arrested rather than summon them. Or for whatever reason, why would we have this person arrested? All those rely upon the prosecutor to be able to establish the satisfaction of the pretrial chamber judges. Okay, once the judges have fully satisfied themselves that the grounds exist which are plausible, reasonable, justifiable to be able to have this person arrested, probably that is a flight risk. Once he gets to know that he's being looked for, he would not be available or already is on the run, then the judges would, in those instances, authorize actually the issuance of a warrant of arrest for a person to appear before the court for the proceedings to be taken. Usually, actually, the other factors they would look at is, as long as the prosecutor may want to present the argument that as long as this person is at large, he is a danger, for instance, to the witnesses. He may want to extinguish the witnesses, or alternatively may influence the witnesses so that they would not be able to testify against him. So in effect, they could advance the argument that without this person being held in custody, there's a possibility of the accused tampering with the entire investigation process to prejudice a fair trial that would be able to come up. Maybe the person is on the rampage and possibly without him having to be arrested, there could be further crimes, more serious crimes committed by the same person. Actually, the concern largely would be further international crimes being committed by the person. So once all that has been presented before court, now we have a warrant of arrest issued. What is the procedure from there? The prosecutor is now armed with a warrant of arrest for Mr. X, being suspected of having been committed acts that amount to genocide along with particular people. So that is why we remember we had about 4 organs of the court dealing. One of them was designed to deal with administrative and operational matters to support the other organs. And this, in retrospect, you recall we said was the registry. And the registry does a lot of coordination between the court and the other states in terms of cooperation and those administrative issues, operational issues. So once the warrant has been issued, the registry takes over the warrant, and it is up to the registry now to coordinate with the particular states that are concerned. And as we said, really, the ICC, without cooperation of the states, ICC relies entirely, almost 100% on cooperation, its success on cooperation of the other states. So it is very clear to point out from the start that without the cooperation of the other states that are involved in the particular states, the operations of the ICC would be really rendered nugatory, or would be stifled, would be frustrated. So the registry coordinates with the states and seeks their cooperation in terms of arresting the person. And then it's not just arrest. Once the arrest has been effected, there's, as I said, there's the issue of surrender. You can have the person arrested. He has to go through the municipal criminal procedures in order to be able to establish and validate the processes, ensure the person and that his rights are observed in terms of arrest. All these, the court is clearly keen to see that its procedures are above board, that there are no interests of the accused person, because at this stage, the presumption is that the persons are innocent, presumed innocent until the contrary is established. So the courts in those countries where the individual suspects are would if they cooperated, that is, the countries cooperated, the states cooperated, the arrest would be effected. They would execute the warrant. That is, if they're able to get the accused and be presented before the courts for the normal procedure. Okay, so we have the arrest. Then there's the issue of surrender. Ultimately, the accused is needed at the Hague to appear before the International Criminal Court. So apart from the arrest, there has to be a surrender. Once the processes domestically are fulfilled and satisfied, then the accused person may be surrendered to the Hague for detention. We'll look at that. Okay, but remember, there are times when the accused person may not be in a particular state, so the warrant would be available in most of the states to be able to ensure that the accused persons are located and are promptly brought before the court. Okay, after having arrested the accused, and we now assume that the process has gone on satisfactorily before the local courts, what happens is that there's need for, of course, which is a matter of proper procedure, for the accused person to get to know what charges are being proffered against him. So, and given that the court is an international court and operates across the globe with different languages, this warrant would have to be made available to the accused person in a language that they do comprehend clearly, and they would seek advice to understand the nature of the charges that they are faced with. Okay, so as I stated, the ICC, the International Criminal Court, 100% relies on the cooperation of the states. And the states are under an obligation, responsibility to cooperate. It is provided for in the statute. It's debatable, of course, whether there's a duty to cooperate or an obligation to cooperate or a responsibility to cooperate. That is for another day. That's a full debate for the whole day that we shall address. But in essence, the courts, the states have a responsibility under the statute to be able to cooperate with the court and support the proceedings of the court by way of arresting the suspects and surrendering them to the court. Okay, so as you can see, without those states, the ICC would not be able to secure cooperation or secure the execution of the warrants. But what happens where, as we saw recently in cases where al-Bashir could fly to South Africa and the authorities at that time did nothing about, and the warrant of arrest was out for him? Okay. The Rome Statute contemplated situations such as those. I'm not referring specifically to that, but any other instance where the state does not cooperate. When the state party does not cooperate with the ICC in terms of arrest or any other proceedings, the matter would have to be referred by the court to the Assembly of State Parties, which is a congregation of member states for further decision and action, so that there's collective responsibility to ensure the spirit of the Rome Statute is sustained. All right, that was that. So it's also important to know, once this person has been arrested, of course, they would be in the custody of a particular country that in which they're arrested, and the procedures, as I said, would depend on the procedures of arrest, of determining validity of warrants and all that. So the accused person also has a right to defend himself and even to resist if there are any flaws that are involved in it. And once all is surmounted after the state, it would now be time to surrender the accused to the Hague. So what happens at the Hague? The Hague is just an institution to ensure that the court judicial proceedings proceed well. So there is a detention center at the Hague where the accused person would have to be held. And the standards that would be maintained there are those of the that are observed by international United Nations, international instruments governing the rights of the detained persons. So there's a minimum standard that must be maintained in those places. It's a small cell they're detained in, probably around 2.5 or 3 by 3 meters, around 10 meters squared, well maintained, and they are supplied with the meals. They have access to a number of things. And remember, at this point, they're still innocent, presumed innocent until the contrary is established. Their guilt can only be established after a valid, unappealed trial before the chambers. So at The Hague, they are taken care of. They're given access to their visitors, to legal representation, where the court it's satisfied that the person accused has pecuniary challenges, they would be able to provide legal assistance, so that, because these are very serious charges, and one would not represent themselves given the complexity of the proceedings before the International Criminal Court. Okay, so in a nutshell, the treatment of the accused person in detention at The Hague is maintained. There's a level that must be maintained. Medcare, they have communication with the guards, intercom, and all that, knowing that they're not yet imprisoned. Okay, for now, I want to stop at that point, because we'll now proceed to see what rights within the court's trial. We're going to get into the trial, but for now it suffices to note, as a recap, that once the pretrial chamber is satisfied by the presentation by the prosecutor, it will be able to authorize the issuance of the warrant of arrest for the accused, or summons to appear. And if the reasons actually would be that possibly there's interference, there's a potential that the witnesses would be interfered with, the investigations would not be properly, would be actually tampered with, and it could be a problem. He could continue committing crimes. So once he's brought before the court, then detained, and the matter is now ready for trial, pre-trial chamber and all those processes. So I'll stop at this point, and I hope to proceed at the next lecture with what happens at the trial stage. Thank you for listening. I'm Dr. Advocate MILTON, Professor Advocate MILTON, Professor Dr. Advocate MILTON, PhD, International Criminal Law. Thank you very much.